First of all, I want to say a special thank you to Brewster, to Adam, the entire team at AIF for hosting this today. Please give them a round of applause for doing this. And before I introduce the panel, let me do a real quick survey. How many of you in the audience buy automobile insurance? Okay. How many of you buy homeowners insurance? Very good. Keep doing that. And I'm going to assume, because everybody here works for a business or an association, you are buying virtually every line of commercial insurance. So what that translates into for the next 25, 30 minutes, this panel is going to talk to you about something that is important to you as a consumer and important to you as a business. So our panel today, the four of us, we have the 2 national trade associations and 2 state trade associations. Combined, we represent probably somewhere north of 95% of the insurance being done in the state of Florida. So to my right is Michael Carlson. He is with the Personal Insurance Federation of Florida, another state trade like the Florida Insurance Council. Caitlin Murray is with NAMIC, the National Association of Mutual Insurance Companies. And then Katie Webb represents APCIA, which is also one of the national trades. And again, as a group, this is probably north of 95% of the insurance being done in the state of Florida. I'll ask each one for an opening comment, and then we're going to go. Our topic is the one-way attorney fee, which is, from the standpoint of the insurance industry, is clearly number one at the top of the list on all the tort things that we're trying to address. So let me ask each one. I'll start with Michael. Any opening comments, and then we're going to go hit one-way attorney fee hard.
Thank you, Cecil. Good morning, everybody. It's great to be here. I want to thank AIF and Brewster and Adam and the team for putting this forum on today. I think it's a great idea to bring the business community together, particularly the financial services community, excuse me, to discuss these issues. They're so critical to our customers, to our businesses. As Cecil mentioned, I'm the CEO of the Personal Insurance Federation. We're a national state trade of national writers with a significant market share in auto and homeowners. We've got about $12 billion in the auto market and $1 billion in homeowners. So the issues we're talking about are absolutely critical to our members and to our consumers. And I just want to thank you all for being here. And I want to thank you again, Cecil and Katie and Caitlin for being on this panel. I look forward to it.
Good morning. Yes, I want to echo thank you, AIF, and Cecil and then the panelists for putting this together, and then continue that gratitude towards the governor and the legislature for the reforms that they have pushed so far, and they have got across the finish line, which is why we're here to kind of see what's next. But I'm Caitlin Murray, and I'm the Regional Vice President for the Southeast for the National Association of Mutual Insurance Companies. NAMIC represents over 1,500 local, regional, and national carriers, and about $16 billion in annual premiums in Florida alone. So I'm happy to be here, happy to participate, and I'm looking forward to it.
Thank you, everybody, for being here today. My name's Katie Webb. I represent the American Property Insurance Association of America, or APCIA, also a large national trade association comprised of upward of about 3,500 member companies at this point. So thank you all for being here. Brewster, thanks again for putting this very esteemed group of folks together to talk about this. And I see we also have some policymakers here. So to dovetail on some of what you've heard, thank you all for the progress that you've put forth on this issue as it relates to insurance matters. And we've started with property. I think where we're going, hopefully, is to see how that could benefit other lines of insurance. And because it looks like the property market got to a point of a point of crisis. And it still may be in a position where it's going to take some time to really experience some of the reforms that have been implemented. But I think as we see that start to really take hold in the property market, it will advise us on what to do next in some of these other lines.
Thank you. I'm going to ask Michael to start. The thing I think for all of you to understand is when we talk about one-way attorney fee, what exactly is it? Michael, if you could kind of give them an explanation, because sure. I think everything starts with education, understanding what is it this thing is doing.
Yeah, I'm happy to. Thank you. Many of you may know this, but in the United States, generally speaking, there's something called the American Rule regarding the award of attorney fees in civil litigation. The American Rule basically says each side pays their own attorney. There are two very important exceptions to the American Rule, one of which is a statutory basis for an award of fees in civil litigation. Another way is by contract between the parties. You, as business people, may have had contracts where you've got an award of fees if there's a lawsuit and one of the other sides prevails. In Florida, the particular fee shifting law, as we call it, that we're going to talk about is Section 627.428 of Florida statutes. Those of you following the recent legislative special sessions have probably seen references to that. That's a very particular fee shifting law that only applies in the case where an insured, a beneficiary, or an omnibus insured prevails in a lawsuit against an insurer. And that's the statutory provision regarding the award of attorney fees. Florida case law has expanded that statute basically to include assignees under an assignment of benefits. I think everybody probably knows what that is. And assignees, even though they're not named in the statute, if they prevail pursuant to an assignment, they're entitled to an award of fees. Why is it one way? The only party that can get fees in a lawsuit against an insurer is the plaintiff. The insurer can never be awarded fees under the fee shifting law. And that's what it is. It's really a combination of the assignment of benefits provision and the attorney fee provision, which has led us down the dark road that we've been on, caused a crisis in the property market, is really aggravating our auto market. And I want to thank the policymakers who are here as well for taking action really decisively in December on that. But that's kind of a quick overview of what the one-way fee is.
Thank you. And Katie talked a little bit about the property market. If you look historically at the last 4, 5, 6 years, that segment of the market was losing about $1 billion a year. So what that translated into, our former commissioner had to keep raising rates. So on your homeowners, when you saw it going up 50, 60%, that was occurring. The way I translate it as a non-lawyer is that the consumers of Florida were facing a tort tax, because what that abusive litigation was doing was driving costs up, and you, the consumers, are the ones that have to pay for it. So let me shift a little bit. Caitlin, if you can, or Katie, talk about a little bit about how Florida looks compared to the other states. How are we different, or what do we have to do to catch up, if you can?
Yeah, sure. I can kick it off. Well, so in my region, I have 8 states in Puerto Rico. I have mostly coastal states, so we definitely see similar problems, but litigation really is really the factor that's playing into it. And although it's not as aggressive in other states as it is in Florida, it's definitely not an apples and oranges comparison, but a state like Louisiana, who's haven't seen the same struggles with their property market and with their insurers not going insolvent. But the bigger issues there, which we might see as a result of 2A, or as a result of the behavior shifting in the litigation environment, is they are abusing the kind of bad faith statutes now. So Louisiana, for example, when they file a bad faith claim, or there's bad faith litigation, the insurers are more concerned about the penalties that are associated with those claims, that if they don't pay it, and they're found to be in breach of bad faith, and so they're just overpaying. So it's a similar behavioral problem in other states, but it's different based on the statutes that they're abusing.
Right. So I think what really led to the series of special sessions that we had on specifically on property and the resulting reforms that we have seen passed by the legislature and signed by the governor, is it really can be encapsulated by a statistic that you probably all have heard several times by now. Our former insurance commissioner, who I don't think is still in the room, I think he may have had to go, but he cited a statistic many times when he was speaking about the problems that he was seeing in the market. And I might not get the number exactly right, but it was something to the effect of, even though across the country, the claims affiliated with Florida were roughly under 10%, like let's say 8.5 to 9%, the resulting litigation that occurred in Florida represented almost 80%, I think it was 77, 78%.
79.
Of litigation that was actually occurring across the country. And that is a mind-boggling statistic when you think about it like that. Now, there could be several factors that go into that, but a lot of analysis was done across using an entity and using some data from the National Association of Insurance Commissioners that really pinpointed litigation as the main cost driver of premiums in Florida, and then by extension, the one-way attorney fee adding to the incentive for plaintiffs in Florida to initiate litigation. So I think if we're talking about really kind of like what we did to get here, what really was something that we've seen in other states and across the country, we have seen that comparison and the disparity that Floridians are exposed to, not only with their premiums, but just in the virtue of all of the things that we have tried to do to fix the problem that haven't really worked. So one of the phrases that I know we all use when we are advocating for reforms on tort and reforms and just on abusive litigation is what we see from the plaintiff side is a game of whack-a-mole. We might see a proliferation of litigation in certain subject areas or certain types of claims that are the new cottage industry of the week. And we would fix those very precisely, and by we, I mean the policymakers here in the state of Florida, would fix them very precisely within the context that was presented to them at the time. So, I mean, we can go as far back as mold, and then asbestos is one from a while back, and then as we saw time go by, as soon as there was a statutory structure to curb litigation on very specific things. Sinkhole is one. AOB, the proliferation of AOB lawsuits was another. What we saw the plaintiff side do is they would just move to a different area. And suddenly, when the sinkhole reforms were implemented, nobody had a sinkhole anymore. But everybody started having different types of claims. So what I think we have been able to do with the data that we have been analyzing for years, and data is always very helpful in our advocacy efforts, is that we were able to demonstrate in the terms of the property market how the game of whack-a-mole was actually playing out. And I think that when push came to shove as everybody was evaluating all of this, everything pointed to the one-way attorney fee statute being a mechanism that was abused and contributing to this game, to the gamesmanship on litigation. So I think that really we've got a unique problem in Florida with this particular statute. There's not a true apples to apples, as Caitlin mentioned, comparison with a number of other states. There are other states that have fee shifting mechanisms, but not quite like ours. So this is a unique Florida experience, and ultimately, the more litigation that occurs in Florida, the more consumers are paying for insurance.
And I think we can definitely anticipate seeing that behavior shift to a different area. I mean, this is, I think we're going to talk about PIP and auto glass. A lot of this cottage industry, they have a system in place that they can just shift over to that area. And I think that's really the concern that we're looking at in the future. And just an example even of the education that some of these law firms are providing. They have conferences. When I was employee at the Office of Insurance Regulation, we would receive materials from those conferences, and I think we did like an AOB sublimit, like you could do the two different policies. And one of the slides I remember seeing is mold is gold. It was a way to get around that sublimit. So I certainly, it is a unique to Florida situation, but even more special about Florida is we will see that behavior continue some way or another.
Yeah, if I could just add to that, I mean, going back in time, when I started my job in 2011, by 2012 we had members saying we're getting this strange pattern of claims where we're seeing something called an assignment of benefits. And a lot of research has been done. A lot of people in this room have worked really diligently on this issue. And we had a slide up a minute ago, and to Caitlin's point about training, Sometime in the early 2000s, the trial lawyers interested in insurance claims figured out that they could leverage that assignment to get attorney fees. They figured out that you could do that really easily. You could entice a vendor, whether it's a mold remediator, a water remediator, a plumber, et cetera. You could entice that vendor to join with you in a crusade against the insurance company. The goal of the attorney is to make as much money in fees as he or she can. I am very respectful of the trial bar. Their entrepreneurial spirit knows no bounds. Harvey Cohen, who had the slide up we had just behind us a minute ago, basically was the Pied Piper of AOB and attorney fees. And he led a crusade to educate vendors to take advantage. He had a black American Express card that was actually his business card with a thumb drive built into it that had all the forms a vendor would need to take a valid assignment. As soon as they have the assignment, they own the claim. They are, under law, the insured. Therefore, they're entitled to fees. So the whole game becomes, how do we file as many lawsuits as we can? Someone earlier mentioned sue and settle. Exactly. How do we file a lot of lawsuits, and how do we settle a lot of lawsuits? I just saw a note from Ashley Khalifi a minute ago, who tracks a lot of this data, that somebody filed 50,000+ PIP lawsuits in 2022 alone. One single lawyer.
And 70,000 the year before.
70,000 the year before. We see tens of thousands of auto glass lawsuits over $100. And the payment of the indemnity is dwarfed by the payment of fees to the insurer. One of our members has a 85-15 ratio in those kinds of claims. They're paying 85% of the dollar amount to an attorney for fees. They're paying 15% to the vendor. The whole mechanism is designed to transfer wealth from insurance ratepayers to trial attorneys, unfortunately. And I think the legislature has really done a tremendous job in trying to nip that in the bud in the last special session in a way that doesn't harm consumers, because there are still consumer protections out there. But I really think this is a mechanism that was dreamt up by attorneys. It was marketed by attorneys. The solicitations are by attorneys to enrich themselves. They don't care what the public policy ramifications are of that program. And I think the legislature finally realized that that's the nature of this problem and took pretty significant action in December.
Yeah, I'll just follow up on the auto glass and the way these systems that work in the real world. I live over in Jacksonville, so what I've experienced in the last year or two is they hook up with some of the local glass companies. So I take my wife's car, my car, to the local car wash. My wife's car has a little chip in the windshield, so I pull out, and this guy comes to me. He's got a nice golf shirt, says it's glass company, and he said, "I see you have a broken windshield." I said, "Well, I got a little chip in the windshield." And he said, "Well, I can get you a free windshield." And I said, "Well, before you go into all of this, let me explain to you who I am. I am president of the Florida Insurance Council." And he looked at me with a smile and he said, "Terrific, you know what I'm doing." I said, "Well, I don't think that's the answer you wanted to give me." I said, "Tell you what we can do. Let me record all this." And he backed up and he called his boss, and they literally stood out in the parking lot and waited for me to leave, which was kind of a signal. They probably didn't want to continue to fix my little chip in the windshield. But to Michael's point and Caitlin's point, yeah, they have a business model to do this. And what concerns me, and maybe you guys can talk about this a little bit, as Katie and these folks have said, we want to give the policymakers data. What I've generally seen is when these things surface, the data is fairly small. The AOB, the first call I got was from one of the presidents of one of our domestic companies, and he said, "I've had like 200 of these in a year." 4 years later, he's looking at like 100,000 of these. Yeah. And that's one company, and then you spread it across the domestic companies plus the national carriers, and it becomes a $1 billion program. So in a nutshell, what I would say to you is, yes, I think you all did a very good job on property. Now the question is, the bad actors don't leave. They go from football to baseball, but they're still the bad actor. And I would just say, what lines are you anticipating? I think we can probably guess, but what lines will be the next ones in the bubble?
I mean, if I could, I think auto comp and PIP are high volume coverages now in terms of lawsuits. But I imagine several of these smaller homeowners plaintiffs firms might decide that auto glass is a more profitable avenue for them to take on clients. I am also worried about, to Caitlin's point, about Florida having a similar experience eventually, a similar experience with Louisiana on the bad faith claiming side. There is a provision in the bad faith law for an award of attorney fees. And one of the things I think the legislature did a very good job of trying to address the Camerata case, which I think has been addressed now. You got to have to show a breach before you try to have a separate bad faith action. That's really a great improvement. But we have some concern that bad faith will become a new area where there might be some attempted abuse. We would hope that that doesn't happen. But I do think PIP and glass for sure are going to be big. I think homeowners should settle down. I really do. I'm very hopeful that that will happen.
And I think historically, property insurance has gotten a lot of attention because the severity of those claims are much higher than some of these claims that we're talking about in auto glass and PIP. But the frequency of PIP and auto comp is much, much higher than it is in property. So we'll certainly, I think, to Michael's point, the property, hopefully, that's the plan, it'll calm down. But I think something that we need to continue to educate policyholders and the legislature and policymakers on is just how insurance works. We'd like to see if we could snap our fingers and it all, the experience take effect right away, that would be wonderful. But how insurance works is these companies have a tail of claims that they're still dealing with. So we're really not going to see the results that we were expecting probably for a little bit.
Right, and I think that one of the things that is, again, a nuance of having a function like the one-way attorney fee shifting statute that we have, the one-way attorney fee statute that we have here in Florida, is it really isn't about the indemnity. There's litigation that involves, claim or an assertion of, a discrepancy in an interest payment, or some very, very small dollar amount that's a dispute between, was your windshield worth $400 or $450? And you would be surprised to see how expensive plaintiff's fees can be litigating over an amount that small. So back in a million years ago, before I started doing the advocacy that we do here in Tallahassee, I actually practiced insurance defense for a short period of time, primarily concentrating on the auto side. And it was shocking to see at the end of the day when we went to a fee hearing to negotiate a fee award over a dispute, people who were just out of law school like myself, had just passed the bar exam, who were being awarded upward of $400 an hour for their time with a multiplier on top of it in the auto context. Mm-hmm. So you've got people who were 25 years old who were making $800 an hour for their work disputing an interest payment. So I think that that is something that the plaintiff side has identified as a very target-rich environment in the auto context, because there's a lot of small, more what would seem to be insignificant claims that occur, but the fees are not insignificant. So that just is a further point.
We hear anecdotal stories of the amount to file that for the lawsuit is higher than the litigated amount that they're going to court over.
Yeah, the filing fee.
Yeah.
Yeah, it's great. To Katie's point, I saw a 5th District Court of Appeal opinion late last week, where there was a PIP lawsuit over $1.28 underpayment of interest, and the appellate court remanded the case to the trial court for consideration of an award of attorney fees for bringing that case. The trial court had initially rejected the request for fees. The appellate court said they're entitled to fees. They're prevailing, even though it's $1.28. And that's kind of just, to me, it proves the point of this business model. I don't know what other evidence really is needed, although I do agree Cecil made a great point. The industry's done a fine job of collecting data. Lots of representatives here have been collecting data and data mining and giving it to the legislature so policymakers can be well versed in kind of the nature of the problem. But to me, the glass scenario is the most egregious. We know what an F-150 windshield costs. We know what labor it costs. How in the world are we getting these inflated invoices? And why are these glass vendors so keen on suing us the moment that they don't get exactly what they demand? And I've looked at the invoices. I've seen these little administrative and other sort of padded fees. If nothing else, they're using those tools to enrich themselves. And the lawyers will take the case. And we've had a member company that had several hundred of these low-dollar glass cases. And the lawyer basically said, I will settle all these glass cases for, I think it was $750,000 in attorney's fees. And they can do that. They've got the leverage because they've got the one-way fee and they've got the assignment. And they have that power to file those cases, thousands of cases. It begs the question of whether they can actually pay attention to all the cases they filed. They just put these in the mill and they grind them out and they demand fees. And so the fee enrichment is really the source of the problem. And I think, I hope that we will continue with the progress that the legislature's already started in addressing one-way fees and move Florida away from that particular, unfortunately, really abused consumer protection tool. It does not protect consumers anymore. It harms them now. And that's a big problem.
And unfortunately, consumers often, when it comes to auto glass, are not aware. There's no deductible when it comes to auto glass. So when they're saying you can get this free windshield, they're like, let's do it. And they don't realize, though, that what they're being replaced with, if it's not the windshield that came with the car, it's aftermarket parts, and usually it's a lot more dangerous, a lot more susceptible to cracks. So it's certainly a conundrum and hopefully something we can look at in 2023.
Yeah, and Cecil, I'm just kind of curious, because you started this panel off with taking a quick survey of room, hands in the room of people who are paying for certain things, and you yourself had a personal experience at a car wash with this type of activity. I'd be interested to see how many people in the room either themselves have experienced some kind of solicitation for auto glass or know somebody who has, because I know I have, and I know in certain parts of the state it's worse, but like, has anybody here experienced that? Yeah.
Right.
The other one will tell you if there's a hailstorm anywhere in your county, somebody's going to come knock on your door and offer you a free roof. We have a cousin that lives about a mile from us, and the hailstorm was actually in Jacksonville. It didn't hit St. Johns County. And they came through knocking, and my wife's cousin said, hey, these people offer me a free roof. Mm-hmm. And I said, did they go up on the roof? Well, there's no leaking. No, they ended up not doing it. But if there's a hailstorm in your area, get ready. There will be somebody knocking on your door. And if you go to a car wash, they're going to hit you up there too. We're almost out of time. We probably could do one or two questions. If we're holding between us and lunch, so I'm always very cognizant of that. Any questions from y'all?
I'll just ask, we've already seen some work done on property. Obviously, we would like to see this expanded. What is the FJA's argument on this? Obviously, it didn't help much this couple of sessions ago. What are they walking around talking about now, as it pertains to potentially expanding, one-way reform into other lines?
Well, I think what we've all heard for, the several sessions that we've all been doing this and working on these issues, their go-to line is a very simple line that's a really, really easy sell and a soundbite, and that's, well, we wouldn't have to sue an insurance company if they just paid the bill. And that's a very overly simplistic way of saying just pay what we're billing you and we wouldn't have to sue you. Meanwhile, there is this mechanism where they have created a business creating, bills that are egregiously overinflated. And part of the job of the insurance industry is to, they've got a responsibility to their customers to adjust those claims and not pay things that are unreasonable. So that's the more complicated answer, but the real simple soundbite is just pay us what we charged.
And I would say on top of that, they argue that we're taking away consumer protections by passing this legislation. But ultimately, I would say the biggest consumer protection in the insurance world is having available, affordable, and reliable insurance. And when you're abusing the system, it takes away that consumer protection. And they'll say it's a barrier to our access to courts. And for everything, there's an argument that they have every time, and it is consumer protections. It's what Katie mentioned. So we've heard it enough, but I think it finally, like we have been saying for years, this is a problem, and we need to fix it now, or else we're going to be dealing with it, that problem and our new problem 7 years down the line. And so I think, it's being heard.
I would say, Brewster, just to reiterate, the common argument is it's an access to courts problem. My grandmother is not going to be able to get her roof repaired because she won't be able to afford a lawyer. The truth of the matter is there are at least 2 other statutory ways to get attorney fees. We all know that public adjusters take a percentage of the indemnity for their payment. Lawyers in the liability area take a percentage of the indemnity payment in a BI case. They're not paid by one-way fees. They're paid out of the indemnity. In the offer of judgment statute, that provides an avenue to fees. The bad faith law does provide an avenue, for fees, hopefully for very legitimate bad faith claims. So there really isn't a reduction in consumer protection or access to courts. But, like Caitlin said, I think Katie said that, these simple messages sometimes get traction. Oh, there won't be any attorneys available to take your case. I am absolutely confident that the trial bar will continue to be very smart, very entrepreneurial, very creative in finding ways to profit.
All right, let me thank Michael, Katie, and Caitlin for doing this, and Bruce,
Cecil.
we'll turn it back to you. Thank you.
Thank you.